All right, good afternoon. Today's Tuesday, April 4th. This is a meeting of the House Judiciary Committee. We are taking up hearings on a number of Senate bills. We only have till 2:30. Okay, so we're going to try and do this as quick as possible. Senator West is with us for a series of 3 bills, starting with Senate Bill 195, 210, and then 56.
195, 210? Oh, 210, yes. Okay. I've got too many bills here.
4 bills. You're right. 209, 195, 210, 56.
4 bills. Okay. Thank you, Mr. Chair. If I seem a little out of breath, it's because I just literally ran over here from the Senate floor. Let me deal with Senate Bill 209 first. This is a task force to study crime classification. A similar bill was passed 4 years ago. It was to be a multi-year task force to study all the crimes in the state which are collected in the Maryland Code. And they're not just in the criminal law article, they're all over the code. And they've been added higgledy-piggledy over the years. You add a crime with that relation to other crimes. And in some cases, they make sense. In some cases, you have one crime which is relatively insignificant, but it has the same penalty associated with it as another crime which is far more significant, and vice versa. So the purpose of the study is to try to bring some order out of chaos in terms of Maryland's criminal laws. This time, instead of, and what happened 4 years ago was COVID hit. And so the committee, which was expected to work for several years, simply never had a chance to get together and do what it was supposed to do. So it basically died of warning. So we're trying to regroup. And this year's bill is very simple. This year's bill only requires crimes in the Maryland Code to be dropped into classifications. So, for example, all the property law crimes should be collected and dropped into a category called property law crimes. All of the sex crimes ought to be collected and dropped into a category called sex crimes. It really is not terribly difficult, and that it's a one-year bill. The complicated bill will be next year. So once we have all the crimes in their categories, for example, all the property law crimes in the property law crime category, next year will be the more difficult job of associating apples with apples and oranges with oranges and grapefruits with grapefruits, so that insignificant crimes are treated the same, and much more significant crimes are again treated the same, and their penalties associated with the crimes will be more logical and will fall where they should fall in terms of the continuum of penalties that could be assessed for various crimes. That would be next year's bill. This year's bill is merely to take a long passage through the entire Maryland Code, which you have on the shelf over there, and go article by article and take out every single crime and put it in its proper category. So that's all this bill does. It passed, I think it passed unanimously in the Senate, 45-0 in the Senate. There is a cross-file in the House, but it never got out of rules. So that's where we are. I'd be happy to take any questions about the bill.
All right, thank you. That's a task force bill. There's no opposition. There's no one signed up against it. That's going to end the bill hearing on Senate Bill 209. We're going to move to Senate Bill. Yes.
It's a quick question. Thank you, Mr. Chair. This is a bill I worked on before I was elected back in the day, so it really is important to me. I see y'all broke down to 1 member of the House and the Senate. Is there any reason for that from 3?
Well, we don't expect this year's work is going to be very significant. So there's no need to have, and it's not going to be making judgment decisions, just categorizing bills in various categories.
Understood. Thank you.
Next year's bill, by contrast, will be a lot of work, and we're going to need more state senators and more delegates on the commission.
Understood. Makes sense. Thank you, Mr. Chair.
All right, let's move on now to Senate Bill 195.
Thank you, Mr. Chair. So this is Senate Bill 195 entitled Orphans Court Judges Election. So the orphans courts are a bit of a hodgepodge. In 3 counties, the circuit court judges serve as the orphans court judges. Those counties are Montgomery County, Howard County, and Harford County. So in those counties, there are no elections of orphans court judges because the circuit court judges get assigned on a rotating basis to sit as the orphans court in those 3 counties. In the other 20, I think it's 21 counties in the state, the remaining 21, orphans court judges are elected every 4 years. This bill puts orphans court judge elections in exactly the same posture as circuit court judge elections are today. It will take them out of partisan politics because I've never heard of an orphans court judge making a decision based on partisanship. It just doesn't happen. Does everybody know what an orphans court judge does? My wife, who is the daughter of the former chief judge of the U.S. Fourth Circuit Court of Appeals, I asked her, do you know what an orphans court judge does? And she said, it deals with orphans, doesn't it? The answer is no, that's not correct. Orphans court judges administer and make decisions about wills. So when someone dies, if there's a contest over the will, that goes to the orphans court, and the orphans court makes those decisions. Holds hearings, takes testimony, and ultimately makes the decision as to how the will should be interpreted. There's no partisan way of doing that. So what this bill does is say that just like in the case of circuit court judges, when there's an orphans court election every 4 years, all of the candidates will appear on both the Republican primary ballot and the Democratic primary ballot alphabetically without regard to their party. And the top 3, in most cases, there are 3 orphans court judges in the county. The top 3 in each party's primary will move on to the general election. So, for example, if candidates A, B, and C win the Republican primary and A, B, and D win the Democratic primary, there'll be 4 candidates on the ballot in the general election, all 4 of them, again, listed alphabetically without regard to party affiliation. That's how we elect circuit court judges. That's how we should elect orphans court judges. I see Juliet Fisher is on the screen. I don't know whether you're taking testimony. Juliet is a strong proponent of this bill. So at this point, why don't I stop and let her continue for a minute or two, then we'll take questions.
Sure, you have 2 minutes.
Good afternoon, Chairman Clippinger, members of the committee. I'm Juliet Fisher. I am a Baltimore County Orphans Court judge, and I have been for the last 9 years. I am here on behalf of my colleagues, Judges Evans and Franks, although I'm here in my personal capacity and not as an orphans court, representing the orphans court. I'm here on Senate Bill 195, which we've tried to get passed in various versions before. Last year, I didn't hear all of Senator West's testimony. A task force to study the orphans court was created, and one of the recommendations was to make the election of orphans court judges less political by allowing them to engage in nonpartisan elections, which is exactly what this bill would do. Previously, my court had sought this change, and we had requested an Attorney General's opinion, and the Attorney General had said at the time, currently, in my view, Maryland law does not require judges of the orphans court to register their political party when running for office under Maryland election law, Section 5203, stating that requirements for party affiliations do not apply to candidates for judicial office. But historically, judges of the orphans courts have registered their party affiliation when running for office, and according to counsel for the State Board of Elections, altering this historical practice requires a statutory change. It's exactly that change we're seeking here today. Because the Maryland Constitution is silent on party affiliation, no constitutional amendment would be necessary to make this change. We're attempting to make the judiciary less political, which is what everyone wants of the judiciary. So we would ask for a favorable report for this bill to do that, and I'm happy to answer any questions.
And with that, I will submit to questions as well.
Delegate Cardin.
Thank you, Mr. Chair. Thank you, Senator. Just real quick, this is cross-filed, I believe, right? But the cross-file is in rules.
Yes.
So
yes,
if-
I think you were the cross-file sponsor.
Yeah, I think I was. So if, in fact, we can get this bill out, we should also maybe talk to the chair about getting the bill out of rules, too, so we can move them both.
It sounds fine to me.
Okay, thanks.
Thank you.
All right, that looks like there's no opposition to that bill signed up, so we can end the hearing on Senate Bill 195, move on to Senate Bill 210, which looks like it's the same 2 witnesses. Senator, you have 3 minutes when you're ready.
Yeah, thank you, Mr. Chair. Senate Bill 210 is a bill about attorneys becoming orphans court judges. So as I said earlier, in 3 counties, the judges of the circuit court are the orphans court judges. But on the other counties, the other 21, people have to run for office. Right now, in many of those counties, there is a prohibition on an attorney practicing law while the attorney is serving on the orphans court, which is a severe impediment to an attorney running. The orphans court judges typically are part-time. They get paid around, on average, $10,000 a year. No attorney is going to want to shut down his legal practice for 4 years or her legal practice for 4 years in order to become an orphans court judge. It's not going to happen, and it hasn't happened. The orphans court deals with very complicated legal questions. The States and Trust article is lengthy, and it has all sorts of abstruse provisions that date really, in many cases, from England in the Middle Ages. So we need lawyers on the orphans court who are trained in reading such statutes and interpreting them for the other members of the orphans court. What this bill does is says that during a lawyer's time on the orphans court, if the lawyer gets elected, the lawyer cannot practice estates and trusts law. And practice everything else. Family law is fair game. Real property law is fair game. Representing plaintiffs in personal injury actions is fine. Representing the defense side in personal injury actions. The only thing the lawyer can't do is practice the kind of law that's going to generate cases that come before him or her in his or her capacity as the judge of the orphans court. So that's what this bill does. It makes eminent sense. If it passes, we'll find more qualified lawyers sitting on the orphans courts, and probably we'll get better decisions from the orphans courts, which are not reversed upon appeal. Judge Fisher, you're next.
Hello again, members of the committee. I will say in 9 years I haven't been reversed on appeal yet, so, but I am an attorney, and in Baltimore County you're required to be an attorney to be an orphans court judge. I do practice law part-time in the family and custody divorce context. There is nothing in my law practice that helps conflicts at all with being a judge of the orphans court ruling on probate and guardianship matters. I do think in the jurisdictions where you are allowed to practice law, you're required in PG County, Baltimore City, and Baltimore County to be attorneys, and everyone there is. And some of us practice law and some people don't. Some of them are retired from practicing law. In Calvert County, which is a smaller jurisdiction, you are allowed to practice law, and they now have 2 attorneys of their 3 judges on the bench. I've spoken to the judges in Calvert County, and they wanted me to tell you, Judge LeBlanc in particular, that he thinks it is such a wonderful thing to have 2 attorneys on the bench. It is hard to learn the law. It is hard to rule on these cases. And even in the smaller jurisdictions where they might have less complex cases coming through, there's still rulings to be made. You're ruling on evidence and objections. You're writing opinions that are going to potentially be appealed. So having a legal background, I don't know how you could do it without having one, honestly, especially in a jurisdiction like Baltimore County. You just couldn't. But I think that this is a good law. It was also recommended by the task force. I think it allows more legal professionals to be on our benches. And I think, you know, we all need to always look for improvements in any of our professions. And I think this would be an improvement to the orphans courts in Maryland. I'm happy to take any questions.
Thank you, Judge Fisher. And let me just conclude by noting that this bill passed in the Senate 45-0. With that, we're happy to accept questions.
All right, thank you very much. I don't see any questions, and there's no opposition on this bill. We have one more bill, and I believe you're the only one signed up on it. Senate Bill 56.
Yes, thank you, Mr. Chair. Senate Bill 56 is a horse of a different color. This bill has been filed for several years in a row, and for each year the Attorney General has opposed it. I believe because of that opposition, the bill has failed. The purpose of the bill, let me give you an example to illustrate the bill. You have a construction contract to replace a bridge on the Baltimore Beltway. An engineering firm has designed the new bridge. On the construction site, a concrete mixer is backing up into the construction site. A flag man is directing the mixer backing up. Something goes wrong and the mixer backs over a construction worker and seriously injures the construction worker. So there's your scenario. Because the engineering firm had to sign a contract with the state to do the engineering work, which contained restrictive language, what happens is if the state gets sued in connection with that construction accident, which the engineering firm had no involvement with whatsoever, the state can tender the legal representation to the engineering firm. And under that contractual language, the engineering firm has to pay the lawyer's fees, legal fees of the state, as well as any damages that are ultimately assessed against the state. What this practically does is it means that small engineering firms, frequently minority-owned engineering firms, are not able to bid on these contracts because they can't sign such a provision in a contract. If they do that, it's a bet-the-company decision. If something goes wrong, the small engineering firm, the minority-owned engineering firm, literally goes bankrupt. So they can't bid. So there are fewer bidders on the contracts. The bids, therefore, are higher. So it has terrible public policy consequences from using this language. So the bill says you can't use a provision like that in a contract. That's what this bill says. Now, we passed the bill in the Senate 44-0, because Delegate Cardin, if I can give him credit, this year went to the Attorney General and secured the agreement of the Attorney General to back off and take no position on this bill. He also went to MDOT, and he got MDOT to take no position on this bill. And he got the Department of General Services to take no position on this bill. It passed the Senate. After it passed the Senate, the MDOT reneged on its agreement with Delegate Cardin. And you will now find an opposition in your files to this bill from MDOT. So that's where the bill stands now. I remain persuaded that this bill is an important bill and a good bill. It's going to lead to lower bids on state contracts and more minority-owned engineering and architectural firms and small architectural and engineering firms getting jobs, which they're not getting currently because this language is being used. But you will have to deal with the opposition of MDOT. Thank you.
We have 30 minutes. 2:30, we're ending. Go ahead.
Real quick, first of all, this bill deals with the way it's amended in the Senate. It deals just with the defense costs for these firms that have to pay for other parties to whatever lawsuit is filed. Is that correct?
That's right. I should have said that.
Okay.
Yes, the original bill dealt with defense cost and the damages. Damages have been struck out of the bill. It only deals with defense costs now.
So if there's, if, for example, a contractor is sued for personal injury, as you suggested in your example, the state could bring in, or the contractor could bring in the engineer who had absolutely nothing to do with it, and it would be determined, 99.999% sure that they would be determined that they were not liable for those injuries.
Correct.
There was no proximate cause with anything that they did. So therefore, but they're still going to have to pay the cost of defense for this.
Yes.
So if we pass the bill, it doesn't mean that the state has to pay the defense costs for all the parties. It just means that the contractor, if they can't get it insured, doesn't have, the design professional doesn't have to pay the defense costs for all the parties. Is that right?
That's correct.
So each party pays their own, as they should, until there's a determined wronged party, and then the party that is found to be at fault is the one that would have to pay basically all the costs per their contractor for the insurance.
That's exactly right.
Okay, and we did get testimony from a number of small minority-owned and women-owned businesses saying they are unable to, I just want to make sure it's clear on the record, they were unable to get, to be able to bid on these contracts simply because of this. In fact, the state rarely even has these clauses in the contracts, but if they are going to have them, these guys can't do it.
That's right.
Okay, thank you, sorry.
It's a risk-the-company decision to sign such a contract.
Nice convo between the two sponsors of the bill. Thank you very much. Thank you very much. All right. Thank you, Senator West. That's
Thank
going
you
to
very
end the
much,
hearing
Mr. Chair.
on your 4 bills.
Sure.
We are going to, I've been instructed, don't blame me, Senators, to play seniority cards here, and we're going to take Senator Smith's, the chair of JPR's, 2 bills next. We're going to start with Senate Bill 592, surplus military equipment.
Sure. Thank you very much, Mr. Vice Chair, members of the distinguished Judiciary Committee. Senator Smith here to present Senate Bill 592. It's a reporting bill. There's a program, a military program called a 1033 program, where our law enforcement agencies are able to acquire military-grade equipment for pennies on the dollar. This is just a reporting bill that says you have to report that information. And with that, I'd ask for a favorable report.
All right, seeing no questions, let's move on to Senate Bill 290.
Thanks. Just before we jump into the meat of this one, I want to say that I was late because I came from the Rules Committee, and I was working to get all those House bills out of our Rules Committee. So there you go. All right. There you go. So for the record, Mr. Vice Chair, Senator Smith here to present Senate Bill 290. This bill, to my mind, really completes the reforms that we started in 2021 with police reform. You'll remember that during that time, we established an independent investigations division within the Office of Attorney General to independently investigate officer-involved deaths of civilians. And this bill before you really completes and rounds out that reform. Now, I remember when I had the hearing in the Senate committee, I presented the report, which was at the time not required by law that the Attorney General presented, or that the IID, the Independent Investigations Division's report. It really highlighted some really great information, and for the first time you had the videos, the reports, the statistics all readily available, not only in this report online, but in your hands. It was the first time that information was aggregated in such an accessible manner. And as policymakers, it really gave us an opportunity to understand other things, like where these incidents were happening, what the people looked like, how old they were. And so, I don't know if that's a fortuitous thing here. Is that, okay, I'll keep going. So for the first time, that's information that we were able to have at our chance as policymakers to make future decisions. So what this bill does is that it gives the Attorney General not only the ability to investigate those officer-involved deaths of individuals in Maryland, but also to the exclusive responsibility to prosecute those cases. So it does that. It also it gives the Attorney General the ability to accept cases from state's attorneys when there's serious bodily injury. That's a permissive thing, so it's not mandatory. And the Attorney General can also investigate and prosecute anything that's any other malfeasance that's found during the course of those investigations. There's an annual report requirement, and then there's a small technical fix in the bill that changes civilian to individual. And with that, Mr. Chairman, I know we're on a truncated schedule. I'll ask the committee for a favorable committee report and stand for questions.
Briefly, please. Said Eric Hand, no Tomlinson.
Thank you, Vice Chair. Obviously, we had a much more lengthy conversation when the House one came through with lots of testimony. And one thing that was brought up several times from the different states' attorneys who spoke and different letters they've sent in was a request for a potential amendment to give the individual states' attorneys a right of first refusal. Have you had any kind of internal discussions about that with the Attorney General?
No, we had extensive debate on that, and if you're looking to make this process truly independent and transparent and accountable, you've got to decouple these things completely. If you give the state's attorneys that first right of refusal, so to speak, you're still going to have that complicated relationship between the two agencies. So right now, the way that the scheme is set up is that after the investigative division completes its investigation, they've got 15 days to turn over that report. The state's attorney makes a decision to go up or down with moving forward with the prosecution, or they decline to do so. If you keep the state's attorneys with the first right of refusal, there are a lot of things that can happen. First is that you still keep that complicated relationship between two different entities that are one's investigating, one's responsible for prosecuting. What if then you're going to put yourself in positions that are, what if the Attorney General's report suggests that there should be a prosecution, or the facts lead there, there's no declination, they say, hey, look, then the Attorney General goes forward to try to prosecute. The fact that the state's attorney has not done so complicates that process. And so if you want a truly transparent, clean process, an accountable process, you've got to marry these two together under the Office of the Attorney General.
Okay. Thanks.
All right, Munoz and Tolles, and we do have people signed up in opposition on this one, so we got some time.
mic's not. Am I on? Okay. Thank you, Mr. Chair. Thank you, Mr. Chair, for coming.
Good to see you again.
My question is in regards to the letter I believe we all got from the Maryland State Lodge of the Fraternal Order of Police just yesterday, so I think this is kind of new. And they're concerned about the misconduct of one of the leaders in the AG's Internal Investigation Division. I guess this was found by an associate judge within the Circuit Court for Prince George's County, and the misconduct occurred during the trial of a former police officer from the same county. And so I guess they're calling for both this and the cross-file to be withdrawn because they believe that having this individual responsible for supervising and investigating police-involved incidences would be a huge issue, and I was just wondering if you could speak to that at all.
No, sure. I'm also in receipt of that letter. I read it, and I thought it was an interesting line of argument to make a suggestion that a legislative body withdraw a piece of legislation because of a personnel matter. Look, that personnel matter is unfolding. I know the Attorney General's requested the transcript from that hearing. This is a structural policy change that we're looking at right here. That's a personnel matter, and so I defer to the wisdom and the judgment of the Attorney General to handle that adequately. We don't have all the facts, we don't have the transcript. I wasn't there. No one in this room was there. The Attorney General was not there. So, I would just defer to the Attorney General on that personnel matter, but this is a structural policy change we're looking to implement, and I would not think that that should frustrate this process moving forward.
Okay, so you don't think there would be any issues with, I guess, this specific group within the AG's office overseeing these types of investigations?
So I think it's an individual, not a group, and I think it's a personnel matter that I'm just not qualified to weigh in on. What I'm offering to you to consider today is a structural change that I think makes sense to ensure that we, I think, increase transparency and trust and mend a broken relationship between our public safety officials and the general public. Again, that's a personnel matter that I'm not qualified to weigh in on.
Okay, thank you so much.
Elliot Tolles.
Thank you, Mr. Chair. My question was answered, but I do have a quick follow-up or just a process. I am aware of it, but just for those that are listening, Mr. Chair, good to see you as always, my friend. Can you explain how in situations where you would have, one judge make a ruling based off some information, based off a trial or, the facts of the case, rather, and then if it goes to appeal, how another judge can make a different ruling based off the same facts, and why that could be important, or how this bill could tie in to a situation like that occurs probably on a regular basis, depending on, what is heard in trial, how the judge, makes the ruling in terms of sentencing, and how through appeal, maybe some more facts, or, I'm trying to get at something without getting at something. So if you could just talk to how judges, how the judges play a role in SB 290, what that would look like, and how important SB 290 would be when it comes to those decisions that judges have to make, or the, rulings they have to make, and why maybe an independent why this bill could be, helpful or beneficial in this situation.
Sure. So this is not a theoretical kind of a gap that we're trying to fill, and there are two examples, and I think this is where you may be going. One occurred in a county which, under the last Attorney General, they actually had to go to court to compel a certain level of cooperation. And so in that instance, the state's attorney declined to move forward with the case and made a decision absent having access to the report that was provided and conducted by this independent investigative division. And so moving forward with a decision with absent all the information was, a problem that this reform will solve. And most recently that happened in another jurisdiction. So this is a very real problem. I think to another point in terms of, I think having a full-throated, independent, very thorough and transparent investigatory process where it's accessible to the public and policymakers, I think lends credibility to any decision that the Attorney General would make moving forward, whether that be to decline to prosecute, declination, or whether to move forward.
Okay, so in that instance, then this bill would be helpful to alleviate as much as possible some of those situations that you indicated.
Well, I think there's yes, I mean, there's an inherent conflict here. It's because prosecutors and law enforcement officers have a very close relationship, and not as was always been stated, not an inappropriate relationship, but it does lend not only to real conflict, but also the specter of conflict. And so, having an independent entity do both the investigations and prosecution makes perfect sense in terms of accountability, transparency for all of us.
Okay. Thank you, Senator. Thank you, Mr. Chair.
We're all hanging out.
Thank you, Senator Smith. That was very illuminating. We're going to take your opponents now. I think that's...
Okay. Thank you very much, Mr. Vice Chair.
Yeah, there are two signed up against this, Rebecca Smith and Stephen Kroll.
Good afternoon, everyone. My name is Rebecca Smith. I am General Counsel for the Maryland Troopers Association. I will not take my full 2 minutes. You've heard me talk about this before, and we'll rely on our written testimony. But the main concern from the Maryland Troopers Association is the checks and balances that come along with giving the prosecutorial power to the IID. And that goes along with what the FOP submitted. This is not just a personnel issue, because there is no check now to make sure that the people being hired by the IID division are going to be up to par and remain impartial during this process. If the power to prosecute remains with the state's attorneys, those folks are elected and held accountable by their constituents. That provides that checks and balance that we're looking for. Therefore, we ask for an unfavorable report. Thank you.
Unfortunately, I have to stop the hearing right now because the House of Delegates has gone back into session. We're going to resume bill hearings after the end of this session, and then we're going to have a voting session after that. So members should begin to make their way to the floor, please. Thank you very much. That concludes the first set of bill hearings for the House Judiciary Committee.